Welcome to Love, Money, Control with Dean Hedeker, Reinventing Estate Planning. Brought to you by Hedeker Law, serving Greater Chicagoland for over 30 years. And now, here are your co-hosts, Matt Halloran and Dean Hedeker.
Hello and welcome again. This is Matt Halloran, your host, joined as always by the founder of Hedeker Law, Dean Hedeker. Dean, how are you doing today?
Matt, I'm doing great. How are you doing?
I am doing wonderfully myself, sir. Thank you for asking. We're going to dive into wills and trusts in really much more of a holistic approach today. We've kind of stayed at a high-level view on our last few podcasts, and I wanted to have the opportunity to pick your brain and get a lot more detailed. And our first question for today's podcast is, how can real estate really affect not just your wills and trusts, but your end-of-life documents?
Great question, Matt. And there are a lot of issues surrounding real estate. Because the thing is real estate is determined, the laws that govern real estate are the laws that are in place at the location of the real estate. So for example, if you have real estate, say in Illinois, and real estate in Florida, the Illinois real estate is governed by Illinois law, and the Florida real estate is governed by Florida law, which is different than if you have like a brokerage account, for example. With a brokerage account, there the laws that govern that account are the laws of the state of your residency. Here with real estate, depending on how many pieces of property there are, you got different state laws. And the reason that's important is because if you set up a trust, for example, in say Illinois, and you got a piece of property in the state of Florida, you have to make sure that property in the state of Florida gets deeded into your trust, just as the Illinois property would get deeded into the trust. If you don't do that, you could have a probate in another state. You can have multiple probates because each state, the state of the real estate, governs is the law that applies here.
Okay. So you don't have to have two documents? It can still be under one umbrella trust, can it? Okay.
Yeah. It's still going to be under one umbrella trust. It's just that trust needs to be drafted in a way where it works in all states of the union, and that takes another level of competency, another degree of expertise. So real estate is just you have the issue of whether it's for example, residential real estate, your residential, the property you live in, versus rental property. Let's say you rent property out. There you have different tax rules there. And so because those different tax rules, you have to, the attorney that's drafting the trust needs to take that into account so that your heirs don't pay too much income taxes after you die, real estate is it's a big issue, and we see a lot of times clients with properties in multiple states. It may be rental property, it could be residential property, and depending on the type of property, we have different considerations here.
Well, and you live in Chicago, right? So, and there are an enormous amount of snowbirds in Chicago. So a lot of seniors, successful people have property not only in Florida, but also, in Arizona, as two states specifically. And you said that those have to be deeded into the trust. This is something that I'm assuming, as you had said, you need an experienced, estate planning attorney who's done this a number of times. And I know that you have a lot of clients who have multiple properties, right?
Absolutely. And then they'll have properties in multiple states and in multiple countries, too.
Oh, wow. Countries. Uh-oh. So
the law of the jurisdiction where that real estate is what controls.
Okay.
And I don't want to make a mountain out of a molehill, but the real estate, this issue of real estate, for example, you mentioned Arizona property. Arizona is a community property state. And so you can have, for example, somebody that's a resident in Illinois owning community property in the state of Arizona, and that could affect, there's some tax issues surrounding that when the first person dies. So again, this issue of real estate in trusts and how you pass it, it's it's a lot more complicated than you would think at first blush.
Well, let's make it even more complicated because you brought up the idea of income-producing properties. So how is that handled differently within the trust because it is an income-producing property?
Well, the thing is with income-producing property, what you got is you got the depreciation deduction that you take each year on your income tax return. And so what happens is say you buy a piece of property for $500,000, and each year you're writing off, say, $20,000 of depreciation deduction. What's happening is that your cost basis, the cost basis of that property is decreasing each time you take a deduction. And so what you're entitled to when you die is something we call a step-up in basis. And so the property then gets reappraised, and then you can take the heirs can take new depreciation deductions on the properties. And this is a big tax break. All the real estate developers take advantage of this, and the Donald Trumps of the world take advantage of this. And the point is that we want to make sure that the heirs get this step up in basis, and so that there's never a tax on the growth and the value of the real estate.
Well, so you just brought up depreciation. Let's talk about appreciation. So, I've been working for GE or some company like that, and I have been given stock or purchased stock at an incredibly low rate, and that stock has appreciated greatly. What do I do with that when it comes to a trust? And explain to our listeners how that might be able to help me.
Yeah, the stocks. Well, the issue with the stocks depends on whether you own those stocks inside of a qualified retirement plan or outside of the qualified retirement plan. So let's take a simple case. Let's assume that you've been buying these stocks in your company, but you just bought it outside the retirement plan. The thing is as you know, if you were to sell that stock, you would pay a capital gains tax on the sale. And many times people think if they set up a living trust, that when they transfer that stock into the trust, that's a taxable event and they have to pay a capital gains tax. Nothing could be further from the truth, though. The trust is kind of like an alter ego of yourself, and so you can put those appreciated stocks into the trust, and you're not going to pay a tax putting them in. It's important that those stocks be in the trust because you want to avoid probate in the event of your death. But the other thing you want to do is you want to make sure that the heirs get something called a step-up in basis on those stocks. So for example, let's say you paid $100 for a stock and it's worth $1,000. Your beneficiaries would be able to sell that stock for $1,000 and not pay tax on the sale. So they avoided tax on $900 a gain. Isn't that amazing?
That's phenomenal. And that's...
Yeah.
But that has to be done within the trust, though. They can't do that outside of a trust, can they?
Well, they can do it outside of the trust, but there are some complicating issues there. And to be honest with you, I think the easiest way to do this is to do this inside of a trust.
Gotcha. Okay.
I think that if you got all these kinds of assets, the best way to handle this is with a trust. Now, the one thing we talked about were stocks that were outside of a retirement plan, but many times these people that work for these large companies, they have stocks inside the company retirement plan. And when that happens, they have issues, for example, when they retire, whether they take the stocks in kind or not, whether they roll it over into an IRA or not. From a estate planning point of view, planning for the IRAs and the retirement plans is complex, and what we want to do is just make sure that the beneficiaries aren't forced to pull all that money out of the retirement plan upon your passing, for example, and pay an income tax on that. We want them to be able to take your IRA or your retirement plan and make it the beneficiaries' retirement plan. That's called a stretch IRA, and so we want to make sure that these beneficiaries take advantage of that.
Okay, yeah, that sounds like a level of complexity that I would feel very happy about handing over to you because I don't actually think I've ever heard the term stretch IRA before.
Yeah, it's amazing. See, what's happened, Matt, is really, when you look at it, most clients aren't subject to the federal estate tax. I mean, the federal estate tax, the exemption is almost $5.5 million per person. They may have a state estate tax, but most people aren't subject to the federal estate tax. And so, what's now come in, and what now is affecting people, is the income tax and these capital gains tax issues on these appreciated assets. Because the stock market, if you look at the market, from 2008 onward, it's run up quite a bit. And so you got clients sitting with large amounts of appreciation in their portfolios. Mm-hmm. So it needs to be planned for.
Okay. Well, let's switch gears here. I actually heard this at a cocktail party. I know that sounds strange. First off, that I would probably go to a cocktail party, but secondly, that this was something that came up, and so I overheard one person talking to another person that they wanted to write a person that they didn't have good relationships with in the family out of the will without them knowing. Are you able to do that?
Yeah, Matt, it's done a lot. The biggest issue you've got when you do this is that your first thing is you want to make sure that the documents are properly executed, because what you're doing here is disinheriting someone who might otherwise inherit something.
Okay.
And so that person is going to have, is going to be very interested. Let's say it's a child, for example. Under most state laws, the children are entitled to a piece of the estate. And so the thing is what you're doing is you're writing in your plan, you don't want your child to inherit a piece of it. Now that child is going to be upset at his siblings, and we got to make sure that there's no grounds, even if that child were to sue, that child doesn't have a leg to stand on. So we need to make sure that, one, you're competent. The second thing is that that the documents have been properly witnessed and notarized. I think that's important. I think the other thing is we want to structure it so that if there are any attorney's fees to be paid on defending this, that the child who's trying to get the will or trust set aside, that child has to bear their own costs. They don't get it out of the estate. We want to put in a no contest clause in there, which says if anybody contests the plan, their share shall be zero. Sometimes what you do in this situation is, let's say there are 3 kids and the estate's $1 million, so each kid would ordinarily get a third of the estate. Maybe what you do is you say to child A, who you want to disinherit, I'll give you $50,000 and give the other 2 kids $950. The reason I say that is that that in that situation, the child has to choose. If the child sues, the child doesn't get the 50. The child may lose on the lawsuit. So this way, at least you give them a little bit to go away. This is I would say this from my perspective. Anytime we see this, and we do see this, we make sure that we draft the documents in a way where they will be totally protected to the extent we can in the event of a lawsuit, because these situations generally will create lawsuits, and we let our clients know that.
Okay. So competency, making sure all of the documents are signed correctly. Who breaks the news on that one, though, Dean? I mean, do you do that as the attorney who wrote up the will or the trust, or is the executor of the estate? I mean, because that's got to be a tough position, and I don't know who does that.
Yeah, that's really tough. Usually, first of all, the client, doesn't want to do that. Sometimes what they say, they want to put in their documents, I am disinheriting child A because of this, this, and this. And I would tell somebody, never do that. Because
really?
Child A would walk into court and say, well, this, and this never happened, or, my parents' version of facts are wrong. They're not competent. There's no reason to do that. There's nothing to be gained by saying I'm disinheriting child A because of, A, B, and C. All I would say in the document is I'm disinheriting child A. The thing is that, we want to make sure that we get proper execution of the documents. And then the thing is, in terms of who breaks the news, many times it falls on our shoulders as the attorneys, because really it's kind of like nobody wants to touch the hot potato.
Right.
And, so we wind up many times breaking the news, and it certainly isn't a pleasurable conversation. And again, we always anticipate when that situation happens that child, as soon as they hear the news, or that spouse, could be a spouse, could be a child, that person, the next thing they're going to do is go to some attorney's office,
right,
and look for a lawsuit.
Okay. You just triggered something, and I apologize. I didn't give you this question, and this might seem kind of out of left field, but so I inherit a piece of real estate. So let's say my parents pass and they have something in Arizona. Both of my parents pass, so I'm the heir of that property. Now, if it's put into a trust, then I'm not paying taxes necessarily when I receive the property, but I'm assuming that if I just turn around and sell it, then everything's wide open for taxation. Is that correct?
The answer is probably not.
Oh, hello.
If
okay.
you inherit a piece of property, say in Arizona, anywhere, if you inherit a piece of property, and let's say it's worth on your parents' death $500,000, and under Internal Revenue Code Section 1014, anyway, under the Internal Revenue Code, what happens is you get what we call a step-up in basis, and so that property, your parents might have paid $100,000 for it,
okay,
and now it's worth $500,000. Your cost basis in that property will be $500,000. Now, if you were to sell it 2 years later, say for $700,000,
right,
you would pay a capital gains tax
on the 200.
On the 200.
So this step up in basis thing is very interesting to me, and I really don't know if everybody truly understands it. Is there anything that is excluded in a step up in basis? Because we've talked about real estate and we've talked about stock. Is there anything else that falls under that category?
Well, what is included in it are things that are included in your estate. The exception is retirement plan accounts. So, and this gets kind of tricky. So the thing is so let's say you have IBM stock inside of an IRA, and you die. What happens is that IBM stock, does not get a step up in basis because it's in an IRA. Every dollar that comes out of that IRA, assuming the IRA is what we call a deductible IRA, that every dollar that comes out of that IRA is taxed income tax wise. So there's no tax gimmick. There's no step up in basis,
okay,
or no tax saving strategy. At least when it relates to this issue with IRAs or retirement plans. This step up in basis, commonly where it occurs is in the area of real estate or in investments that are not held inside of IRAs or retirement plans.
Okay.
That's where it generally occurs.
When you're setting the trust up, I'm going to continue on this line of questions if you don't mind, but when you're setting up your trust and you do have all of these, like multiple pieces of property, whether it's income producing or whatever, before it goes into the trust, I'm assuming that it has to be appraised and valued so that you're going to know exactly and document within the trust the value of each of these properties. Is that correct?
Actually, no, we don't need to.
Really?
We need to, yeah, surprise, surprise. We don't need to know, we don't need an appraised value. Certainly, in terms of estate planning, I want to get an idea of what my client's estate size is, but I don't need to know it to the nearest dollar. And so, really, in terms of putting the assets into the trust when I set it up, I don't get any appraisals at all. But I could tell you this, when someone dies, then at that point in time, I'm going to want to appraise all of the real estate. And same thing is true with the investment accounts.
Okay. So I was at another part. No, it really wasn't a party this time, a cocktail party. I was at a networking event, and a financial services, well, more of an insurance professional, was talking about putting life insurance inside of a trust. I didn't really understand what he said, and his explanation didn't make a lot of sense. What do you do with that, and what are your recommendations? And I know we're going very general here because every specific situation is specific, but is that commonplace within the estate world? Is like a hedging with a life insurance policy?
Well, here's the thing. The thing is if you go through the expense of writing a trust, you want to make sure that the trust covers. You want to have you want one comprehensive document covering your entire estate. And again, and I'm addressing this to the 99% of the world that doesn't have an estate tax issue, because there are some different issues if there's estate taxes, and I'll be happy to go into that. But the point is that assuming we don't have an estate tax issue, you can look at life insurance just as another asset of the estate, and certainly on life insurance, you can name a beneficiary. And so you could name your children as beneficiaries and things of that nature. But it seems to me that if you have a trust document written, the trust document is much more comprehensive in terms of the protections it provides vis-a-vis these assets. And to me, if you got a trust, the trust talks about what happens in the event of your disability, what happens in the event of your death, what rights do the beneficiaries have to the assets, and how do they inherit the assets? So it would just seem to me that the best thing to do with all these assets is to put them in the trust. And so life insurance would be one of those assets that we would put into a trust. That way we've just got more comprehensive planning for in the event you become disabled, in the event, in the event you die, certainly life insurance will convert to cash at that point. But then, then the trust provides protections or provisions in terms of how the children or the beneficiaries inherit those assets. And life insurance is just another asset of the estate. That's the big thing. Now on the larger estates, 20 million, 30 million, there many times people set up what we call life insurance trusts. And the reason they do that is because they want to have a more effective way of paying their estate taxes. Although I have to tell you, it's quite possible the estate tax is going to go away. And I think most estate planners are planning for that. And just because the estate tax goes away doesn't mean you don't need estate planning.
Sure.
Nothing could be further from the truth. But things could change, and you should stay tuned.
Well, and trust me, if we're going to be doing many podcasts if that stuff happens, because with a major change in the administration here in the States, that could make a big difference. And in fact, that last part of what you said was the tail end of this pitch that this advisor had provided, which was this is a great way to hedge against estate taxes. And so what I'm hearing you say is that's only for people who have rather large estates. Did I hear that correctly?
You heard it absolutely dead on, Matt.
Okay.
You hit the nail on the head.
One of the biggest problems that I have seen, as in doing what I've done for the years that I've done it, is people don't talk effectively. The CPA has a very specific idea of what needs to happen when it comes to end of life or disability situations. The insurance professional does, the estate planning attorney professional does, and then the financial advisor does. How do our listeners get everybody on the same page, and who takes the lead? And I'm really putting you on the spot here, and I'm not really very sorry to do that because I'm waiting your answer. But how do you deal with that?
That's a great question. I think the thing is, it's a big issue in this industry, and it's basically the issue is the left hand doesn't know what the right hand is doing.
Yeah.
And the fact of the matter is, the CPA is just preparing tax returns each year, is just focusing on the income tax return. The estate planning attorney is just busy cranking out estate plans for people, and the financial advisor is just making sure that that the assets grow, and none of them talk to each other. It's just because they're busy talking to their clients. And so what happens many times is they expect the client to be the messenger of the news between them.
Okay.
But the problem with that is that the client, doesn't have the understanding, and I'm not denigrating clients at all, but doesn't have the understanding of all of the issues. So, one way to solve that is to have a meeting, or a conference call where all three are present. They could have a conference call amongst themselves, so they could discuss all the issues. That's one way to go. I think, the issue here is we want to be sensitive to the fees and the costs. And when you have, three professionals sitting together at the same time, the costs do add up. And so I think that's an issue. And so the point I'd make is that's the reason we configured our firm or our office the way we have. And that's because we have, I am active in the financial services industry. I am also a CPA. I also have another CPA in the office, and I'm also an attorney. And we have another attorney in our office as well. And I think that this multidisciplinary practice, or whatever you want to call it, or this one-stop service approach, I think this is the way to go. And I think it's the way to go in a cost-effective manner, because the problem is it's going to be very, very difficult to get 3 or 4 people or entities together in a cost-effective manner where they all talk to each other, and all talk to each other regularly, because they need to be kept up to date in terms of the changes.
Sure.
So I think that's a big problem, has been a big problem in the industry. And in response to that, you see these multidisciplinary offices being set up. But to be honest with you, there aren't that many of them.
Right.
And I think it's difficult to set it up if you're going to have multiple owners of the business. In my situation, I own the business, so so it's easier to bring in all those layers of expertise in one meeting.
Well, and I absolutely agree with you, and I think that's one of the reasons why I was so excited about bringing you on board and really having you do these podcasts for the public, is because you do have a multidisciplinary approach, and it is a one-stop shop. But if people aren't using you, the average American has 2 to 3 financial services professionals. They probably maybe have an estate planning attorney, because as you know, very few people have trusts who should. Then I've got an insurance person. I've got a PNC person. Then I've got my CPA that I've been working with forever. How do I even know what questions should be asked to get all of them to answer questions? And again, I'm leaning on you for this, Dean, because I know you know all 4 areas really. So is there a person who I should defer to? It seems like CPAs get deferred to a lot, but they just have such a limited scope on some stuff. So I don't know. I might not be asking you the right question. I'm just trying to pick your brain here.
No, you're asking, these are all great questions, and to be honest with you, there are a lot of these questions don't have answers. It's the the thing is that you're trying to get multiple people together to talk. The other thing is that if we look at, like, in the area of tax preparation, a lot of times people do their own tax returns. I mean, I see a lot of people come in with tax returns that have been prepared by themselves, TurboTax, which is a fine product. And again, not denigrating it, but my point is that that now our client has become the CPA, and so the thing is that you just have all these issues, and I think the only way that you can handle this is a client needs to sit down with somebody that's competent in all those areas. Whether they have degrees or not is I'm not going. I mean, I believe the degrees are important, but my point is that the person a client needs a financial quarterback. Is
Gotcha.
What they need.
Okay.
And that quarterback, needs to be kind of like versed in all those areas. Kind of like if you walk into an emergency room and you see a trauma surgeon, it's this person is versed in handling all different things, and it's a pretty high level of expertise, right? In the hospital setting, and it's a high level of expertise in the financial services industry. So I think that's what people need, and that's the way the service can be delivered in a cost-effective manner. Otherwise, you have all these different people running around trying to talk to each other, not getting a lot of communication done, because of internet and voicemail and tag teams, and it just things go back and forth, and it becomes a mess.
And this is even more vitally important when you're sitting down and working with an estate planning attorney to get your living trust or your will or anything. That's one of those key components that an estate planning attorney like you should say, okay, Mr. and Mrs. Smith, we're getting everything done here. Let's have a meeting of the minds and get if they're not working with a full service shop, get your CPA, get your financial advisor, get everybody on board so that we can make sure that we're not missing anything. Is that a fair statement?
Yeah, because here, let me explain it. Let's say the attorney does the documents. The minute the client walks out the door, the attorney has no idea whether the client titled their assets correctly or not. And even if the attorney supervised that, 2 years, 3 years go by, the attorney doesn't know if the client's kept it up the right way. And so again, we're seeing the account statements. We're seeing the stuff on the computer screen. We see how everything's titled. We maintain the titling over all the years. We know we've got the documents right in the house because we prepared them. And then we got the tax returns. It's the only way, in my opinion, to practice.
Well, and I've experienced that for the last 12 years, is especially since I've worked with financial services professionals almost exclusively. They are always trying to get everybody on board, and that's a really, really difficult thing to do. And obviously, Hedeker Law and the Hedeker brand has solved that problem. And now, honestly, Dean, it's really just time for us to get the word out and tell people that, really what you've set up is what they should be expecting. People go to, and again, they go to Target, they go to Walmart, they go to all these stores because they don't have to go more than one place because everything's there and there's experts in-house. Well, maybe not Walmart, but they have experts in-house to be able to help you solve some of your problems. And obviously you're on a different level than such a mass store, but I mean, you can talk to the other CPAs, you can talk to the other attorney in the office. You've got all of these other resources that your clients and the people who are listening to this podcast can rely on and get answers all in one spot.
Matt, it's exactly the same as the Targets and Walmarts and all that, because my dad was a baker. The fact of the matter is, years ago, people went to a bakery, then they went to the shoemaker, then they went to the candle maker, they went to they went to the butcher. The butcher was separate from the baker, And so my point is that, and what happened is all these mega stores opened up and put all those individual entrepreneurs out of business. And the reason was, why was it? It was convenience. Everything was convenient. Everything in one place. remember telling my dad that that this convenience wave is going to cause severe problems to his business. Ultimately, it did. And my point is that it's the exact same thing in the in this financial services, accounting, taxation, estate planning business. It's the exact same thing.
Mm-hmm. Well, it's such a multidisciplinary approach. I mean, I know financial advisors who, have gotten advanced education in tax and in estate law and wills and trust or divorce or all of those different things. So I think you're ahead of the curve here, and I'm hoping that this really resonates. And as we continue to dive deeper into who you are in your education, your background, and especially some of the more pressing issues that are coming up because of potentially what's going on with legislation and state law. I'm really excited about having you on these podcasts and getting to learn from you more. So, Dean, thank you very much for your time. Is there anything I missed today?
Matt, we've had a great conversation. It's a lot of fun talking to you. Take care.
All right. Thank you very much, and we'll talk to you soon.
Thanks for listening to Love Money Control, brought to you by Hedeker Law, serving Greater Chicagoland for over 30 years. Get the assistance you need to put a comprehensive estate plan in place today and protect your family's future. Download our free estate planning worksheet for creating a secure future at hedekerlaw.com.